A judge in Dallas has thrown out a rule that required a tenant to pay 1 month of rent in order to appeal an eviction. I'm Tony, and this is Real Estate Investing and Landlord News. All right, so I've told you the story about how there's some places where in order for a tenant to appeal an eviction, they have to come up with some money, okay? And Texas is one of those places. So according to the property code, I believe it says that a tenant has to come up with 1 month of rent before they're able to appeal the eviction case, okay? So some people say this isn't fair, it isn't right that, hey, in order to appeal the case, the tenant has to come up with this sum of money. But the problem is that, hey, evictions are expensive for landlords, and a lot of tenants will file appeals in order to stay in there for months longer without paying rent. And that's what the whole point of this law was, to prevent that from happening. And unfortunately, a judge, seems to think that this isn't right, this isn't constitutional, and is going to throw that out, okay? So, yeah, it's a bad deal. I mean, they don't have to do that in most places, but I like this law. I like the fact that, hey, tenants, you have to put some skin in the game in order to appeal this so that you're not just filing frivolous appeals just so you can get free rent. Oh, man, interesting situation, but, I'm going to read this article so that you can know more about it. But before I get into the article, go ahead, hit the like, subscribe button, maybe leave a comment down below. Let me know what you think. What do you think of a law that requires a tenant to pay a month worth of rent in order to appeal an eviction filing? Do you think this is a good idea, or do you think this is a bad idea? Do you think this is constitutional? Okay, I mean, that's an important question here. Is this abiding by the rules of the Constitution? This judge does not think it is. So let's get into the article. This is coming from dallasnews.com, and it says, Dallas County Judge rules payment requirement in rental eviction appeals unconstitutional. Let's get into it. A Dallas County judge on Monday ruled a piece of Texas property code unconstitutional because it violates tenants' due process rights to seek an appeal of their eviction, a legal shift that could impact renters, justice of the peace courts, and property owners, legal experts say. In Texas, tenants who file for an appeal of their eviction must pay a month's rent in order to have their case heard by an appeals court. If a tenant does not pay, a landlord can evict them without an appeal being heard by a court. Judge Juan Renteria ruled in favor of a Dallas woman who argued the statute violated her due process rights, as well as the open courts and equal protection clauses of the Texas Constitution, because it created an unreasonable financial barrier. Here's the problem I have with that, okay? What about the financial barrier that they're putting on landlords, okay? You're telling the landlord, you have to suck it up and keep paying so this woman can stay in your property for free until her whole case is heard? No, that is ridiculous, okay? She needs to put some skin in the game. Actually, in my opinion, she should have to come up with the total amount that she still owes the landlord, because the grand majority of eviction cases are for non-payment of rent. So if a landlord is evicting somebody and this person already owes them 2 or 3 months of rent, then they should, the tenant should have to come up with that entire amount before they're able to appeal. Okay? But, that's not what I'm reading here. What I'm reading is they're saying, hey, we're only going to require the tenant to put up a month, and the judge still thinks that isn't even fair. What a ridiculous concept to me. To me, the law makes sense, and that the judge threw this out, without thinking of the consequences is a huge problem. This is just one step in a long journey toward justice, Dallas Eviction Advocacy Center's attorney Mark Melton said after a hearing Wednesday. Historically, tenants have been railroaded by a system that has not even cared to listen to the facts that would support their rights, limited as they may be. We need to move to a system that cares about tenants' rights under the law as much as they care about landlord rights under the law, because both are equally important. David Cole, a Dallas appellate lawyer with no connection to the case, said the future implications are in a little bit of a gray area because the matter between the parties in this case, the tenant, landlord, and county, are settled. future cases are not bound by the Dallas County judge's ruling. The ruling could face a challenge from Attorney General Ken Paxton, who was notified on June 1st of the challenge to the constitutionality of the state statute. A request for comment from Paxton's office has not been returned. Candice Hunt, represented by Melton, filed an appeal of her eviction on April 29th with an affidavit of her inability to pay. Hunt tried to give a 1 month's rent check to a Dallas County Justice of the Peace court on May 4th, which was the last day she could pay for an appeal to be heard. However, a clerk in Judge Al Cercone's court refused to take the check, which she got from a rent relief collaborative, because it wasn't a money order or cashier's check, according to the lawsuit. On May 5th, the court issued a writ of possession to Hunt's landlord, the Trellis, at Lake Highlands Apartments. So yeah, basically this lady, she was being evicted for non-payment of rent. She went down to some, either nonprofit or government-based rental assistance program. They wrote her a check, and she tried to give it to the court. The court didn't accept it because it wasn't in the format that the court takes. The court says that they will take a money order or a cashier's check, and that's it. I don't blame the court for not taking, just some random rent check from whoever, right? They have their rules. You have to follow them. Okay, but here's the thing, okay? If the landlord knows that you're not going to be able to pay going on into the future, it doesn't matter to me if I get a check from a random rental assistance program. I still want to move on with the eviction. And it doesn't change the fact, too, that you may owe the landlord a far bit more than just a single month's rent. Okay, you might not even be able to fight this case, even if you do appeal. So, yeah, you're really wasting the landlord's time, forcing the landlord to house you even longer, and pay more legal fees. So yeah, when do we get to start talking about that? Because landlords pay a large amount of legal fees for every eviction, and they actually go over that here in this article, right? And let me see if I can find the part where it says where it talks about how landlords have these expensive legal fees, right? So it says, let me find it here. Why does Texas Property Code require renters to pay a month's rent before an appeal? Texas Property Code Section 24.0054 requires that renters who are evicted for failing to pay rent and want to appeal the judgment must pay at least 1 month's rent into the court's registry within 5 days of filing an appeal. The intent of the statute is for renters to not stall for months through a legal process and live in their home for free, Melton said. If a tenant does not pay a timely deposit, the Justice Court should issue an eviction according to the code. At the same time, we also have these constitutional rules that say you should have access to the courts no matter what, regardless of how much money is in your pocket, Melton said. And so those two things cannot be harmonized. In his client's case, Melton argued a person's constitutional rights should not be denied simply because they cannot pay. So yeah, that's a big thing right there, where they're saying that, hey, these people's constitutional rights are being violated by this law. But we can look at places like California, where there are professional tenants who can basically keep filing motions and with the court and keep filing appeals and, say they got to find a new lawyer, etc. And next thing you know, it's been 6 months or a year after the initial eviction case, was heard, and these people are still living up in their property, not paying rent. That's what this law was supposed to solve. And, like they said, it's hard to harmonize the two things, where you're saying, hey, this is person has a right to appeal, their case, and at the same time, not put this too much of a financial burden onto people. But if this person doesn't have the money, okay, keep in mind, the reason that they are being evicted is because they're not paying rent. So what is there to hear if you're still not able to pay the rent and you can't come up with the rent money? Then you don't have a case. you need to go. And that's exactly what this law is saying. So, yeah, I support the law a great deal. And, it makes sense overall for the landlords, for the courts. So, you're not just wasting the money of the landlords, but you're wasting the court's money and the court's time as well with frivolous laws or frivolous cases, frivolous appeals. Okay. So, yeah, I'm in agreement with the law. I don't agree with this judge. I hope that the Attorney General in Texas does, fight this case, because this could set a very bad precedent. And I'd like to see this sort of law passed throughout the entire country, okay? And if it's held up as being something that's legal and constitutional, maybe we can get it passed in other places than Texas.